Okay. Looks like we're starting to get everybody on the Cortland Township case with Do What You Like LLC and the Smiths. Mr. Scales, I see you. You're at your office.
No,
Can you hear me okay?
I can hear you. Can you hear me?
Yes, we can. Mr. Lane, you can hear us okay?
I can hear you great, Judge. Thanks.
All right. And Mr. Smith,
Yes, ma'am.
can you hear me okay?
I can, Judge.
Mr. and Mrs.
Okay.
Smith are both here, Judge.
Okay, that's fine. Give me 1 second if you would.
Thank you.
Mr. Joyce, who are you connecting with?
I'm a neighbor to the Smiths.
Okay. And Matt, I don't have a last name on yours.
McConnon, I'm the Cortland Township Supervisor.
I apologize, Mr. McConnon. I'm sorry, I didn't make the connection right away.
Problem.
Yep. All right, well, these are the tickets that the Do What You Like LLC on behalf of Leanna Smith and Mr. Eric Smith. The files are 20A4116 and 20A4117. The last time we were all together, Mr. Lane and Mr. Scales, you'll remember that the Smiths accepted responsibility. There's two separate violations, two separate files, same violation. One against Do What You Like LLC, one against just Mr. Eric Smith directly. The Do What You Like LLC names Leanna Smith as the resident agent. So for lack of a better way to say it, the ticket is against both Smiths, one being the corporate entity, one being Mr. Smith directly. There may be other people that are on the Zoom, and that's fine. They can listen just like they would be here sitting in court. We'll go forward here today on the punishment phase, if you will, or the penalty phase of the civil infractions. And I saw the very detailed memorandums that both Mr. Scales, you presented on behalf of Cortland Township, and you, Mr. Lane, presented on behalf of the Smiths and Do What You Like LLC. I'll allow for any of the parties directly involved to speak if they'd like to, with you, Mr. Scales, pretty much speaking for the township, unless there's something Mr. McConnon needs to say that we'd need to address. We'll start first with you, if I could, Mr. Scales, and then I'd like to go to Mr. Lane and either of the Smiths if they want to say anything.
Okay, thank you. We did submit a proposed order. It has several parts. With respect to the language of the order of compliance, they did have responsibility not only for having the semis on their property, but also for operating the trucking business out of their home. And we tried to write that in a way that was verifiable to accomplish what the court ordered. The statute does allow the court to enter any judgment, writ, or order necessary to enforce the ordinance, which does give some flexibility for a practical and enforceable order. The way we wrote that, it prohibits semi-tractors, semi-trailers, any commercial vehicle which has a weight greater than 26,000 gross vehicle weight, which is really a very large truck. That's larger than an appliance delivery truck. It could, even a dump truck, for example, might fall under that category. And that's the reason that we put in the suggestion that the trucks on the property not have more than two axles. I've seen pickup trucks that have dual wheels in the back. I haven't seen one that has three axles, though, in a typical pickup type of truck. I do think you can go farther than simply ordering the Smiths comply with the ordinance. They're in a different category than other citizens. In this case, they've admitted responsibility for violating the ordinance. And so I think it's appropriate to order something that allows the township to verify that they are in compliance. The second part of what we asked for were our fees in the amount of approximately $5,900. We did have to get ready for this hearing twice. We did not walk in, or I guess log in, knowing that the Smiths were going to admit the violations, so we did have to get ready to try the case. We did not include any amount for the township supervisor visiting the property, taking pictures. What we've asked for is simply our fees. Mr. Lane did refer to a comment that we made in an email to the court the day that the hearing is rescheduled. That was part of an entry that day that included starting to get ready for the trial and notifying our witnesses that the trial had been rescheduled. We did ask and think that we owed our witnesses an explanation of why that occurred. And the reason for it was that the court continued to cancel in-person hearings for reasons of the pandemic. That was just one entry in the amount of about $165. If the court feels that's unreasonable and wants to delete that, that's fine. The fines are the minimum for 203 days of violations. The ordinance has a $100 minimum fine for the first 7 days, and 200 days thereafter. That adds up to $39,300. That is just for one violation. Technically, there were 2 violations for each of 2 defendants, but it was really one incident, one defendant, so it seems fair not to ask for fines for more than just the one violation. The credit for the road repair, that's obviously in the court's discretion. That's something the neighbors reached out to us on. We do appreciate this could turn into somewhat of a can of worms, so we really carefully wrote what we have in the proposed order to, number one, make it totally optional. If the Smiths think it's not fair, it's not appropriate, if they don't want to do it, they don't have to do it, and would just pay the fine. It's also totally dependent on the parties' ability to agree on something. Again, if the Smiths think the neighbors are being unreasonable, they're being asked to pay more than their fair share, they don't like the contractor, they don't have to agree to it. Nobody has to agree to it, and they have the option to simply pay the fine that the court orders. It was written to give them an incentive, though, to try to agree to with their neighbors to repair the road by allowing $1.50 credit for each dollar. We also wrote it to keep the court and the township out of the role of refereeing any dispute about this. It's up to the parties. If they're able to come to an agreement and repair the road, then the credit would be given. If they can't, then the Smiths would simply levy the fine, pay the fine agreed by the court. With respect to the argument that it's some unauthorized use of public funds, the fine here is paid to the court. It never comes into the township's hands. So there's no, in my view, no issue of an unauthorized use of public funds. And really, this is not much different than what is a typical arrangement where the court might order a high fine, and then if the defendant complies within a certain period of time, they may waive all or part of the fine. So I think it's similar in structure to that. So we'd ask the court to consider that. I think it both has the deterrent effect and the possibility of a positive outcome. I will say that the 1-year payment for the remainder of the fine that we wrote in there was intended to allow for time for the parties to actually have the work done, which is probably not going to occur this construction season no matter what. And so if the decision is made to delete that, we would ask that the court consider adjusting that payment schedule forward because of that.
All right.
Those are my comments. I think we try to be practical and fair and suggest a possible resolution here that might have some benefit for everyone.
All right. Before Mr. Lane speaks, I just have 2 questions on your comments. The one question has to do with the time period that you've calculated your fines. Technically speaking, you are using the days from February 7 to August 28, correct?
That's correct.
Okay. And secondly, the question is, the road itself that you're talking about in paragraph 5, which is the Orchard View Road, is privately owned by the 5 neighbors, the 5 homes that live there. Fair?
There's 4 homes. It is an easement that crosses the 3 properties between the Myers Lake Avenue and the end of the road. So
But that's not a road that the township or the county would have responsibility over. Fair?
That is correct.
Yeah. Okay, Mr. Lane, go ahead and state what your positions are, and then I'll get back if there's anything further that Mr. Scales has.
Thank you, Judge. If it pleases the court, if I can just address the road for one more second. I understand it's an asphalt road that's 20 years old and the neighbors have never been able to agree on how to maintain it. So my understanding is that it has not been maintained and it has dump trucks going down getting garbage every week for the last 20 years. So the damage to the road from the Smiths would probably have to be worked out with an engineer and could be a very small percentage. But I also think that it would be hard to use township penalty funds for private repair. And so I think the matter of the roadway is something that the neighbors are still someday going to have to figure out between them. As far as the Smiths and their trucking company, they have complied with the court. They did it during COVID-19, and they've been in compliance since the last time we were here. And I guess we're just hoping that that does satisfy the court. I understand there's a lot of bad feelings in this situation, but I don't think we have to address them. And I think the court is probably familiar with some of them, but I just want to say personally that I have total trust in you, Judge Smolenski, in doing what's fair and equitable.
Okay, I appreciate that. Mr. Scales, did you have the need to have Mr. McConnon speak or say anything or not?
I don't believe so, Matt. Do you think that's necessary?
I don't have any further comments, Judge.
Okay. And there may definitely be, I met one of the neighbors that was on the Zoom a minute ago. He might still be listening. But what I was, and there were other, Mr. Bell testified at the hearing, and a doctor that is a neighbor was on the Zoom. And so I think pretty much all the neighbors are aware of what's happening here. Of course, they've been living it. And they've been living it, for a good long time. I wanted the Smiths, Mr. Lane, if they do have any desire to speak directly, to say anything either one of them wants to say in addition to what you've addressed.
Thank you, Judge. I don't think Mrs. Smith does. I don't know about Eric. Are you satisfied? Do you have to? Or- I think we're
Okay,
okay, Judge. Well, wait a minute.
Mr. Eric,
Yes, Your Honor.
go ahead. I said
Well,
Eric, I meant Smith, but I was saying Eric Smith. Okay, go ahead.
This started out years ago between myself and Mr. Bell. It's just a straight personal vendetta. We've done everything we can. There's nothing we can do right at all. I mean, it doesn't matter what business it is. It doesn't matter what we drive. It doesn't matter what we do. It doesn't matter, Mr. Bell has made it perfectly clear, including after our first hearing about this. He told me again, all I had to do was move the dumpster and this would stop. He's relayed that to the township. He's relayed that to Mr. Scales. He said it to several times. The last time the township supervisor said, we want out of this. We're not going to use our funds to, settle a personal vendetta. And then we got a new supervisor and it popped right back up. The FOIA shows for the last year that the only emails have came from Mr. Bell, not from the Gullivers, not from Mr. Joyce. The only emails that came from Mr. Bell in a 6-month period. And it's just somebody that takes 60, 70 pictures and communicates with the township attorney on a nightly basis. And the township attorney and the township supervisor continually drive down the road on a daily basis is at best unhealthy. It's just a straight personal vendetta. And I wish the court would step out of it. I mean, we've done what the court has asked. We will do what the court has asked. All we want to is be treated like any citizen in Cortland Township. Not a citizen that's had a problem with the township before on a separate business that Mr. Scales keeps bringing up over and over and over again. This is a different business. This is a different time. We have not disobeyed any court orders whatsoever and do not intend to disobey any court orders, and just want to go on with what we have. So the amount of fines they're asking for would just bankrupt us. I mean, I don't know if that makes them happy or worse, but those fines would just, any business we have would be bankrupt. So, and then employees will lose jobs, township will lose taxes. I mean, townships will lose taxes. And it's for a trucking business that operated for 6 months with no trucks that ever came down over 30,000 pounds ever. And Mr. Scales maybe has done research, but an average dump truck weighs between 50 and 80. And there's 2 of those per week for the last 20 years. So we have tried with the Bells and the other neighbors to get some sort of agreement with this road. I think Mr. Lane submitted emails that we sent to Mr. Bell, and that we have sent to Mr. Bell several times since 2011. And the only maintenance that's ever been done has been done when Mr. Bell said it's going to be done, and it was for about $2,000 of the gravel to put down the sides of the roads to keep it embedded after one of the contractors said that needed to be happen. We've continued to try to set up a bank account. We've continued to try to email Mr. Bell. We've gotten quotes. Mr. Bell has said on several occasions that he does not wish to do any maintenance to the road. All that he wants to do is wait till it goes to crap and then replace it fully. That he said that. I mean, we've had meeting after meeting about this. It's been tension, and that's what it's been. So, and now he's looking for a sideways deal for a 6-month trucking business to pay for a road that's 20 years old and has been dilapidated for almost half of that. I don't know what else to say. I'm a amputee. I'm disabled. We work as hard as we can, and we just want peace. And it doesn't happen. I mean, you got a neighbor that calls a township attorney, not an ordinance officer, and gets a township attorney and a township supervisor involved on a personal level during COVID. And it's just, it doesn't make any sense. I mean, it's personally, he never used the ordinance officer. There was never a complaint filed. The FOIA shows no complaints filed with anything at all. He sent personal emails to Mr. Scales and Mr. McConnell, and it was planned between the 3 of them in this last 4, 5, 6 month period. So we also had a house fire, a pretty significant house fire in June, and that hindered us from getting things moved as well. So we got the summons in the end of April. We have worked diligently at removing all equipment and keeping all equipment off the property. There has not been one truck tire on that property since you asked us not to almost a month ago, ma'am. And we have done that, and gladly done that. So just to keep the peace. So the truck will not come back. Right? We just want peace. I just want this personal vendetta that Mr. Bell has. It's his. I mean, he carries that on his shoulders. It doesn't need to be carried on my shoulders. It doesn't belong in the township. And that's it. We are not do what you like. This is do what you like trucking.
Can I just inquire about the 2-axle issue, because that became an issue in the language?
Yeah.
What is your position on that 2-axle? Are there vehicles that you use in your regular family household situation that are more than 2 axles?
Yes, I mean, I have 2 trailers that have 2 axles, plus my truck has, my truck is a 1-ton truck, ma'am, and that has a GVW of 2999, 30,000 pounds. So essentially, they're saying I can't even drive my personal vehicle down there at that point. They didn't do the research.
When you're talking about the trailers that have 2 axles, that's a trailer that's pulled by that personal truck.
Correct. Yeah. And then I'm
And
also.
what is the trailer?
I have a snowmobile trailer, and I have an open gooseneck trailer, like equipment style trailer, ma'am.
Yeah, but what's it for?
I use the equipment trailer for my, to haul my tractor back and forth to up north, and then the snowmobile trailer. The snowmobile trailer is used for snowmobiles and different type of things. It's an enclosed trailer. It only weighs 2,500 pounds. So.
Is the snowmobile trailer enclosed?
Yes. Yeah.
Uh-huh.
Yes, Your Honor.
Okay.
And then the trucks that were on there, they weighed 30,000 pounds or less with a trailer. So that would do, in a 6-month period, would do no significant damage to a road, none. So, and my wife and I are both working on our CDLs as well, and have started the process, and halfway through the process. I have to have a special thing because I am an amputee and disabled to get my CDL. But if we do get our CDLs and we do have a truck and trailer, not running a business out of there, but just like any other citizen in the township that would drive for a living, should, they're allowed to bring their truck and trailer home and have it there for up to a 20-day period if they are, actively using it. And if we do, I don't think we should be penalized any different citizen. I mean, we're not going to bring a trucking business back. They keep wanting to bring this golf cart business back into it. We didn't bring a golf cart business back. They've inspected it a total of 6 times, and that's not anywhere near it. We won't bring the trucking business back. We just want the same treatment that any other citizen would have in Cortland Township. There are several trucking companies in Cortland Township, larger than mine, one less than 1 mile from my home that we provided pictures of. And it's right off the same road that I live on. And Mr. McCon and Mr. Scales drove by it, have driven by it every day for years and have done nothing about it. So that guy operates a larger scale deal than I do, and the township doesn't do anything about it. There's 2 roads over on Shaner. They've done nothing about that. These are wide open. Mine, you actually have to search to find. So, and we've complied, and we're already doing more than any other citizen that has a trucking company in Cortland Township, Your Honor. So we just want fair treatment, and we want this to go away.
Okay, that's fine. Thank you, Mr. Smith, for your comments.
Thank you.
All right, Mr. Scales, do you want to follow up with anything?
Well, I certainly have not driven up and down this private road or by the other operation on Myers Lake every day for 2 years. We don't have a vendetta against the Smith. I think the pictures speak for themselves. There was a trucking operation that involved as many as 5 tractors and that many or more trailers. It was a very significant operation. It's not the type of operation that's allowed in a residential district. Mr. Smith did bring to our attention the operation on Myers Lake. I think it's called RJ Trucking, and we are in contact with him and addressing that issue as well. The one on Shaner, I don't think we're aware of. But since the court's been in the new courthouse, I think Cortland Township has been in front of this court maybe 3 times, including the 2 for the Smiths. So the township tried to obtain compliance voluntarily. In this case, we just haven't been able to do that. So we would ask that the court enter the order substantially as we have provided it. With respect to the gross vehicle weight, the pickup truck with 26,000 pounds of gross vehicle weight, that would be a 13-ton capacity. That just is incredible. I did check the types of trucks that fall into various categories, and the 26,000 gross vehicle weighted rate is a very large truck. And so I think that's an appropriate break point for what's allowed there and what's not.
Okay, thank you for your comments, Mr. Scales. Just so that you're not left out, Mr. Lane, is there anything final that you want to say?
No, Your Honor, I think Mr. Smith. Well,
Okay. There's a couple, and Ms. Smith, I know you're back there. I don't see you and I don't need to, but I just want to make sure you're listening to everything too, because as Mr. Scales said, it's really both of you, but it's like, the violation is one, but we're looking at the company and we're looking at Mr. Smith, which whatever happens to the company happens to both of you. Whatever happens to Mr. Smith happens to both of you. I get that you're a family. I get that, you're always going to take the position, just like your husband just described everything. I'm not here to argue with you, Mr. Smith or Ms. Smith, about is it a personal vendetta? I don't know Mr. Bell any more than I know you, either one of you. This isn't about, to me, I'm not Oprah or Dr. Phil. It's not me trying to resolve a neighborhood dispute. It's strictly, are you in violation of the township ordinance or are you not? And, realistically, the way you describe it, Mr. Smith, trying to do everything right and you want peace. You know, it's a matter of being educated enough about your surroundings, about that location, about that township, about that residential area, and then comparing it to everything you guys wanted to do when you decided in early February that you were going to start this do what you like trucking business. Because to me, as I indicated, I don't know Mr. Bell, I don't know you guys. My position isn't, you know, of course there's some dysfunction and disputes between the neighbors, but the reality of it is I'm looking at it like, did you follow the rule or did you not follow the rule? And, you know, it's not about do people complain or does a neighbor make a complaint? Or, you know, it's like I can't, the guy over on Shaner, I have no idea what that is. Eventually I'll get that if they get charged. You know, it's like a speeding ticket. You know, 5 cars are speeding and the police officer stops 1 car. I get that that can happen and other people were speeding. And if you use my example, the frustration you're feeling is you're the one that got the ticket. But we'd like to get the word out there to have nobody be speeding, so then nobody gets the ticket. I get that it doesn't mean people that speed and don't get a ticket should just think they're winning. Maybe they feel that way, I don't know, and maybe I'm using a bad example. But your position is just treat us like you would anybody else in Cortland Township. And all I'm saying is follow the rules. All I want is compliance. You want peace, and I get that. And thank God I live in the neighborhood I do because I love my neighbors. And I feel so lucky to say that when I hear what's going on in some of the neighborhoods I listen to. But the reality is this was something that was known quite a long time ago. And I respect the fact that you're trying to do a business for your family and that you're handicapped so that it's even harder. Somebody else might have some other, might not be a physical handicap, it might be something else that really makes it a challenge. But Do What You Like, LLC, was doing business in direct violation of the home occupation ordinance of Cortland Township. And while we did talk a lot at the hearing, you both admitted it. You both admitted it. Now, there was some description of not knowing at the time, not knowing exactly what the rule was at the time, thought we were in compliance or what, but it's clear that you weren't. And Mr. McConnon writes the ticket like, you know, if you ask any of your neighbors, you know, this isn't something that just happened recently. This has been going on for a long time. You categorize it as 6 months, Mr. Smith. If you talk to some of the neighbors when they've seen the activity with the trucks, it's been well over a year. I'm not going to pick about dates here. Mr. Scales focused on calculating fines with dates. And while I know that the supervisor, Mr. McConnon, you know, was alerted to this and saw the violation and recognized the violation and brought it to your attention, the first letter that goes out is the 5th of February. The Smiths get the letter. Maybe I didn't commit it to memory. Maybe there was some talk about Do What You Like carts because it sounds so much like Do What You Like LLC. But they were specifically the township representatives talking about the trucking business. It's in violation. Get your act together. This is not acceptable. And then they say, Mr. Scales says, you're telling them, the Smiths, that Mr. Hanel represents us. So then he starts writing Mr. Hanel. Mr. McConnon wrote the tickets to Leanna Smith at Do What You Like LLC and Eric Smith at the same time for the exact same violation, so that everybody's clear and everybody's covered, to make sure it's known the township does not want this. I am sure, not sat down with any of the neighbors, don't know the neighbors, heard Mr. Bell at the hearing. I am sure that they've been disappointed by how this has been handled. From everybody from the township, clearly disappointed with the Smiths, clearly disappointed probably with the township, and probably disappointed with me. I mean, I don't know, and I can't speak for them. They can, you know, they can have their own opinions, of course, like any of us do. But All they want is for people to be held accountable in their neighborhood. Don't run a commercial business in a residential site, period. Now, you guys, I am not an expert in truck machinery. I wouldn't know how much a truck weighs or how much power it has, or, I mean, visually, I think I would know how many axles it has, but I am not Joe Mechanic. So when you guys start talking about all of that, I said at the original hearing, all I want is compliance. Just on this Do What You Like LLC, I need compliance at the Smith property because their residential home site on Orchard View cannot run a trucking business out of it. I'm not a computer wizard in any way either. And I think of a home business of you're sitting at your kitchen table. I think I said this before to Miss Smith. You're sitting at the kitchen table and you're doing all this computer work. I mean, look at all the people right now in the world that have to work from home. I mean, people are working from home because of the COVID pandemic. It doesn't mean they're running a commercial business out of their house. They're sitting at their kitchen table doing all their computer stuff for 8-10 hours a day. But they're not having trucks come in and out of their driveway at their house. They're not having, I guess I made my point. I don't need to belabor it. But the scenario is this isn't new. And while you'll always believe, Mr. Smith, it's a vendetta, as frustrating as you and your wife find this whole thing to be, you put yourself in this position by trying to run a commercial business out of a residential property. And while all the neighbors that are listening to me are going to feel frustration and stress over some of the decisions that I make today about how I'm handling this, it is difficult, and I'm sorry for what you've had to go through. All I want is compliance. When you think of the terminology of this, the citation itself, both to the LLC, and I don't know why Leanna Smith, yours is the only name on that Do What You Like LLC, because you made the choice in February, and that's why you get the ticket and it's in your name. Then they wrote the ticket for Eric because he owns the property too, because you both own the property. So that's not unusual. We see that all the time. I don't know why, if it would have been Leanna and Eric named under Do What You Like LLC, we'd be talking to Leanne and Eric on that ticket, and maybe they wouldn't have written another ticket with just Eric if they had both names. But the reality of it is, in a sense, whatever happens to one of you happens to both of you, because this is a joint effort on your part, whether you call it a LLC and then it's your personal house, which you both own, or not. It's that we cannot have a commercial business running out of the residential home. I'm not trying to be funny in any way, but it did dawn on me that when I've read this Do What You Like, and I get that this is not the golf cart case and not the golf cart business. I get that. And everybody's talked about that, and it's not a huge focus to me. But Do What You Like. The irony doesn't escape me because I feel like Mr. and Mrs. Smith did that. You just did what you wanted. You didn't check into it enough. You didn't look into it enough. You didn't do your homework enough. You just did what you like. You do what you like. And that's what you did. You started the trucking business, and it grew, and it got bigger, and you were making money, and you had to do repairs, and you yada, 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 whatever's involved in a trucking business. But big problem. Can't do it from that property. Can't do it at that location at all. Period. Sit at the kitchen table working on the computer? Yes. Having the trucks come to the property, having the trailers come to the property, having the hoods up and working on mechanics? No, absolutely not. Mr. Scales tries to do the math when you look at the actual zoning ordinance on what it allows for payments and for fines. The fine shall not be less than $100, no more than $500 for the first offense, not less than $200, no more than $1,500 for subsequent offenses. And they talk about how many days becomes a subsequent offense. And that's how he did all this math. With before you know it, he's looking at 193 days, times all these fines. And all of a sudden we're up to $40,000 practically. And and that argument was made at one point about, potentially, well, you ran that business out of your home for the better part of 6 months to a year, never had to rent another place. How much did that save you? How much is a commercial plant get for rent if you had to rent another place to have all this, which is allegedly what you tried to do, according to Mr. Lane, when you got word that, oh, by the way, you didn't do all your homework and you can't run it out of your home. I get that you're saying, Mr. Smith, that you think it's a personal vendetta, and there's nothing I'm going to say that's convincing you, that will ever convince you otherwise, nor do I have the desire. Believe what you believe. But I'm telling you, my decisions are made by what I look at as a blatant disregard for the ordinances there. I mean, I get cases where, they don't look into it first. They buy the property. Now you can't build the house. Can't build the house that you planned on building because it doesn't fit into that. Well, you just paid for the property. People have to do their homework ahead of time. If the house is just to live in, great. It's a super spot. Can't use the house to run your business out of. Should have been looked into, should have been checked into, should have been known. And some would argue you did know. And then maybe did what you wanted anyway. I don't know for sure. But I'm not looking at this as a personal vendetta, and I'll get to that in a minute when I go over the road repair issue. But let me just say that no matter what I decide in the end, I recognize clearly that the Smiths, Mr. Lane, Mr. Scales, Mr. McConnon, perhaps clearly the neighbors, whoever's listening, I don't know them all. I respect that everybody's going to have their own opinion. And I'm not up here to get accolades. I'm just trying to be the umpire, calling it like I see it, making my decision, and moving on. I do agree with Mr. Smith that I'd like to have peace too. So let me just address the issue with the road repair. In all due respect, the township nor the county really have anything to do with that road. And while I think Mr. Scales, as the township attorney, made a valiant effort on behalf of the neighbors who undoubtedly are talking with him and explaining their complete and utter frustration, which is why I said they may feel like the township let them down before now. They certainly think that the Smiths violated the rules, and they might think that the judge isn't on ball with everything. But the bottom line is, this township and this county, they've got nothing to do with that road. And I'm not going to try to create an agreement whereby somehow there's a credit given to the Smiths toward fines that they would owe to be used toward the repairs. I mean, it's ingenious perhaps, and it's creative, but I don't disagree with Mr. Lane when he says it's a recipe for disaster. To me, the road repair is a separate and distinct issue. It's going to have to be resolved, and it would not surprise me one bit. It's a lawsuit. Small claims, Judge Judy, Judge Wapner, we have them all the time. I'm not disputing that it would be something where the neighbors, if they can't agree, have to come to court on. But I cannot make this case part of a repair of a road where there's been no evidence presented to me, that I can say that over this 20-year length of this road, or whatever, life of this road, how much percentage is because of the trucking business that the Smiths had for the last 12 months, that they say is 6 months, that others say is more like 16 months. I just am not getting into that, because the county doesn't own the road. The township doesn't own the road. If they did, I think I have much more authority over it. And I think I could address it as part of this case and say, well, what is the percentage? Even if there was a separate lawsuit, we'd have to do the study on, how much is their responsibility. How much is the dump truck that comes every week for the last 20 years and the like? I'm not going to add some separate agreement for road repair. It's problematic, and I know it's disappointing to the homeowners who, again, must feel frustration that, nothing ever got done and they're let down again, perhaps by the authority. But realistically, I don't think I have the authority to order a private road to be corrected and to put money into some pot that would pay for it. Here's how I've decided the township attorney fees and the fines. And I get that people are going to be in disagreement with this. I've gotten a figure that I've made, and I didn't do the math like multiplying 100 by how many days or how many. I did kind of the court has discretion, and while I realize the fines are set for a certain period of time, I didn't do the math as calculated as that. But what I did do is I looked at when the tickets were issued to the Smiths, April 23rd, and when they got the last truck and equipment off the property, August 28. And I'm really focused on that time period, not February 2 or February 7, February 7, 2020, when Mr. McConnon wrote the tickets, and then delivered them because of the shutdown. And I'll be honest with you, I do think that COVID played a part in all of this with everybody. I think it added a delay from the court's perspective, no fault of the court, to Mr. Scales' perspective, no fault of his, to Mr. Lane representing his clients, to no fault of theirs. There was some scheduled appointments that we had that would have been hearing this earlier. I don't know exactly what dictated the August 28 date where Mr. McConnon could say now the property was in full compliance. And I do get that the Smiths caught themselves in a time period that was extremely difficult. And that is part of the reason that I don't go back and calculate the numbers the same way that Mr. Scales did. I don't use the same number of days, and I don't use the same amounts. To be forthright, I picked a figure that's going to be divided in two because I'm looking at two separate citations, one with the corporate entity and one with Mr. Smith, even though I've already indicated that it's pretty much one, because whatever happens to Do What You Like LLC affects Mr. Smith, and whatever fines Mr. Smith has affects Leanna Smith and Do What You Like as well. Having said that, my decision is going to be $15,000 fine. It's $7,500 per entity. Mr. Smith on the one ticket, Leanna Smith and Do What You Like LLC on the other. $7,500 each for a total of $15,000 to be paid within 1 year with a payment plan set up by our court that we do with anybody who owes money to the court. With the township attorney fees, I've allotted $4,000 of attorney fees to be paid to the township. I am already addressed the issue of the road repair and will not engage in making that part of this decision, as I believe it's not proper in my earlier comments. We must have full compliance. I've already ordered cease and desist with the commercial business. Now I say any commercial business. I mean, I don't want it to be something from trucking and then something else later, a year from now. I want whoever's in that property or any property to know what the rules are and follow them exact. As far as the language with reference to paragraph 2, and I think you had a copy of that as well, Mr. Lane, the biggest issue with that was the motor vehicle with more than 2 axles. And really, I think the language, and easy for me to say, I just got done saying a minute ago that I'm not a mechanic and I don't have all the answers on the weight and everything else. But however the commercial motor vehicles are defined by Section 7A of the Michigan Vehicle Code, I think that's what should be maintained in that language, Mr. Scales. I think if you take out any motor vehicle with more than 2 axles, It doesn't prohibit, it doesn't stop us from saying no commercial vehicles. Some commercial vehicles might just have 2 axles. Some commercial vehicles might have more. I'm not entirely clear, but I don't want it to be defined. Whereas if he has a personal vehicle that are some of these big F-250 pickup, whatever, that people have, that really a personal vehicle that you use, take the kids to school, whatever, that is a truck. It might have more than 2 axles, I don't know, or however he described it engine-wise, but I'm not really talking about that. So I would just ask you to take out that language, Mr. Scales, about any motor vehicle with more than 2 axles, and just, describe semi-tractor, semi-trailer, any commercial motor vehicle as defined by section 7A. The rest of that language I find is appropriate and is acceptable and should be included. It's only the language about the 2 axles. But I will say to the Smiths and Mr. Lane, you need to advise them accordingly. They have to be extremely conscientious about making sure that there is not a commercial business taking place, regardless of what vehicle it is. I don't care if it's a moped. If there's commercial business going on, it's a problem. This is something that has to be completely cease and desist, as we've talked about. Paragraph 1 in your order is fine the way it is, Mr. Scales. Paragraph 2, with the exception of the language I just took out on those 7 or 8 words. Paragraph 3, it would be 4,000, adjusting that amount. You have in here that the township attorney fees have to be paid within 30 days. I don't know what the financial situation is. I'm not in objection to that, but I'd want you, Mr. Lane, to let us know if that becomes problematic, because I don't want to start having 10 more hearings on this case because stuff can't be done. And Mr. Scales, I want this order to be prepared and sent under the 7-day rule so Mr. Lane can respond to it. Paragraph 4 is going to be the 15,000, still joint and several. I specifically said 7,500, 7,500, and it should probably be noted that way because there's 2 separate citations. The total is the 15,000, but the 7,500, 7,500 per ticket. Are you with me on that, Mr. Scales?
Not entirely. Is the 15,000 joint and several for each one?
Yes, I mean, it's a total amount, but it has to be paid, 7,500, 7,500. But because it's one family, the max is 15,000. So if I'm saying it incorrectly, I don't mean to be problematic. It's just the amount under your paragraph 4 is going to be 15 and not 39.3. Paragraph 5 is stricken altogether, but there should be a paragraph in there about the road repairs are not being considered as part of this judgment. Paragraph 6 should be inclusive the way it is, and paragraph 7 is inclusive the way it is.
Your Honor,
Yes.
this will bankrupt us personally and in business. So I don't know. I mean, it can be a million years, but we don't have this money. So I don't know what to do. We don't have this money on a business level. We don't have this money on a personal level. So
Yeah. You're going to just have to talk to Mr. Lane and discuss things further with him. There are people that owe money to the court on fines and court costs, and there's all kinds of ways that they set up to try to figure it out. I don't know what else to tell you. Okay, what questions, if any, Mr. Scales, do you have?
This one, should we include some language that there will be no commercial business conducted out of the property?
Yes.
Okay.
Mr. Lane, any questions that you have?
Your Honor, if I could just get a clarification on the joint several. You originally said 7,500 to each entity or person and entity, so that Mr. Smith wasn't burdened by the LLC and the LLC wasn't burdened by Mr. Smith. So yeah, is it 2 separate or is it the 15,000.
My intention was to be 7,500 on Mr. Eric Smith under the ticket that is his, which is the one that is 4116, 7,500. And the one that is the LLC, which has the resident agent as Leanna, 4117 is 7,500. Total, it's 15. Separately, 7,500, 7,500.
So, Your Honor, if one of the, say the LLC went bankrupt, would the second 7,500 go over to Mr. Smith? Making his penalty 15,000?
I'll go bankrupt.
I hadn't really thought of it exactly like that. Like, if Miss Smith dies, what would happen to Do What You Like? Or I'm not sure. My intention is to just handle it so it's, you know, why did the township write it the way they did?
We wrote it that way because Do What You Like is operating the business and Mr. Smith is an owner of the properties.
Right. And that's what I had indicated originally, you know? So I'm just saying, I don't think just because the business goes bankrupt that the 7,500 doesn't get paid. You know, they'd still go after the resident agent, and that's Ms. Smith. I'm not looking at that all of a sudden the $15,000 fine, which, you know, I mean, you got to go back and you're looking at this. If you do it by the book, the way the numbers look according to the ordinance, you're in the figures of what Mr. Scales was talking about on a daily basis, that he used a different number of days than I did. My 127 days is more than 15,000 if you do it the way they added up. I'm just trying to do what I think makes the point. They're not going to get themselves in this predicament again. They pay the penalty and we're done with it. I guess to answer the question outright, I don't believe just because the corporate entity goes bankrupt. Well, I think that asks bankruptcy questions that I'm not sure I have enough wherewithal to know. To be honest with you, I'm not sure I know 100%. I'd probably want to talk to a bankruptcy expert.
Well, Your
But I
Honor,
don't want to try to foresee the future. I mean, when people get fined for other civil infractions and they don't have the money, we try to work with them to pay it.
Well, if I can make a point, bankruptcy aside, the Smiths, for example, could form Do What You Like 2 Trucking LLC tomorrow, transfer all the assets to it, and that would leave this current entity without any assets. And
Well,
so,
I'm not talking about whether Do What You Like LLC has assets. I don't know if they have assets. I don't know anything about the financial part of it. I just know that they were running a commercial business out of a residential home, and I've made the decision not to go with the extent of the fines up to what the ordinance allows, using the discretion of the court. I divided it, I picked the 15,000, divided 7,500. My intention was not to eliminate 7,500 of that fine, because I said from the beginning, whatever happens to her happens to him. Whatever happens to him happens to her. It's one household. The money's coming out of the same pot, whether they pay it or not. But just because Do What You Like might go bankrupt or dissolve doesn't mean that my order today goes by the wayside. 7,500 has to be paid twice.
so Your Honor, just for clarity, if Mr. Smith died, Do What You Like LLC would owe the entire 15,000. Am I understanding that, Judge?
Well, that's a different question than saying Do What You Like went bankrupt.
I'm just trying to understand if these two are applicable to one or the other party, or if they're two.
Right. All right.
I guess my suggestion would be simply to make the 15,000 a joint and several liability. We can characterize it as 2 separate fines, but that the responsibility for the whole thing is joint and several.
Right. I think that's the way it should be, joint and several. And I wasn't looking at all the possibilities of what could happen. Really, what I was focusing on is having compliance first and foremost. I mean, clearly it's a huge penalty. It is a huge penalty, and it could have been much huger, if that's a way to say it. I just want it to be not repeated and not back and not have an issue with it. I mean, there's nothing today that we didn't know then. Same with the Smiths. So, I mean, it's difficult, it's not easy, and like I said, but at the end of the day, there's gonna be people that disagree with it, and I'm not here to convince. I'm just saying, I want compliance, full compliance. It's a little bit like talking about the different weights of the trucks and the different wheels, and can you do this, can you do that? You know, meet with the township official and find out before you buy a truck, before you bring it onto the property. I mean, this isn't, it shouldn't be rocket science. It's a residential property that we want to keep residential, period. And really, if the homework would have done at the beginning, they would have known that and maybe did know it and did it anyway. And that's why part of the punishment is as stiff as it is. Okay, that's it. Now, Mr. Scales, you prepare the order, file it under the 7-day. Mr. Lane, take a good look at it. If we need to talk again, the three of us can get together.
Thank you, Your Honor.
Okay? All right, any other questions that you have at all, Mr. Lane?
No, Your Honor, thank you.
Mr. Scales?
I'll prepare the order right away.
Appreciate that.
Thank you.
All right, thank you, everybody. Thank you, Mr. McConnell. Thank you, Mr. and Mrs. Smith. Okay, we're adjourned.
Thank you, Judge.
Thank you, Mr. Lane. Mr. Scales?
Thank you, Judge.
Okay. Is there anybody in the Zoom that's looking to talk to the court if you're in the wrong room at all? Mr. Quinton? Ms. Golliver? Anybody for Jay Hen? Anybody on a Galaxy Note 10? Can anybody hear me right now? This is Judge Smolenski. Okay, I think we can end it. Oh.